Hello, this is Law and Terrorism, the podcast series. I'm your professor, Glenn Torres-Spelliscy. Thanks for joining me. Thanks for joining me for this week's edition of 5 Key Questions. The topic this week relates to the use of drones in cross-border raids in the war on terror. So let's get started. Unquestionably, drone strikes directed against combatants on active battlefields are allowed under international law. During wartime, drones are considered like every other weapon, and drone strikes are judged based on the same criteria as other weapons. But one of the benefits of drones is that they aren't limited to active battlefields. Are strikes outside of active battlefields legal under international law? Well, both the Bush and Obama administrations openly adopted an approach to the war that envisioned a worldwide battlefield against terrorist non-state actors. This allowed for strikes against suspected terrorists regardless of where they were located. We saw drone strikes in Pakistan, Yemen, and elsewhere outside of traditional theaters of combat. The Trump administration and the Biden administrations both operate under the same general understanding, with the Trump administration launching a drone strike in Syria that killed an ISIS leader, Abu Bakr al-Baghdadi, and the Biden administration launching a drone strike in Afghanistan after the war had ended to kill al-Qaeda leader Ayman al-Zawahiri. Since the onset of the war on terror, every U.S. administration has maintained the right to launch lethal attacks against alleged terrorist leaders wherever they are located. It is the use of the unmanned aerial vehicles that has allowed this conceptualization of the world as a battlefield to take shape. Now, actual international law is less clear on the issue. There does not appear to be any support under international legal principles for the premise of a worldwide battlefield. That being said, the laws related to battlefields are generations old, and perhaps do not reflect the realities of the global fight against terror effectively. Prior to 9/11, the conflict with terrorism was nearly universally understood to be a criminal law issue. However, in the post-9/11 world, the conflict, at least with international non-state actors, has been militarized. This is a significant distinction because criminal law and the laws of war have vastly different rules regarding when force, particularly lethal force, may be used and against what targets. As discussed further below, if the conflict with terrorism is to be governed by criminal law, then the rules of international human rights law, IHRL, apply, imposing strict limitations on the use of force by state parties. Whereas if the conflict is governed by the laws of armed war or armed conflict, then the laws of war apply, and states are granted much greater latitude with respect to the use of force. Under the criminal law enforcement model, lethal force may only be used when necessary to protect the life of another person or persons. It is only to be used as a last resort when there are no other options available. Article 6 of the International Covenant on Civil and Political Rights, the ICCPR, one of the foundational documents of international human rights law, provides, quote, "Every human being has the inherent right to life. This right shall be protected by law. No one shall be arbitrarily deprived of his life. The UN has held that it must limit circumstances in which authorities can take someone's life. The use of lethal force by state actors is only permissible when strictly and directly necessary to save a human life or is sanctioned through a legitimate judicial process. The use of force outside of these strict limitations is prohibited by international law and represents an illegal use of force." So how do these principles apply to the modern terrorist age, and in particular to U.S. practices with respect to the pursuit and targeting of terrorists? Well, the use of drones to launch attacks against suspected terrorists is unquestionably a form of targeted killing. Philip Alston, the former Special Rapporteur on extrajudicial summary or arbitrary executions for the United Nations, explained that targeted killings are the intentional, premeditated, and deliberate use of lethal force against someone not in the custody of the perpetrator. Such practices may be lawful in situations of armed conflict, but they are not lawful when in a law enforcement paradigm. A targeted kill operation has only one goal in mind, and that is the lethal use of force. There is no desire or attempt made to capture the individual. Lethal force in these situations becomes the first rather than the last choice. So if we adopted a criminal law enforcement paradigm, the conclusion is clearly that the use of drones to conduct lethal strikes against suspected terrorists is likely a violation of international law. In the context of an armed conflict, however, the targeted killing of individuals is permitted, provided that the individual is a legitimate target, the use of force is necessary, proportional, and the perpetrator takes appropriate precautions to protect as best possible civilian lives. As discussed previously, a legitimate target includes a combatant or fighter as well as a civilian who is fighting alongside the armed forces for the period of time the civilian is directly participating at least. So if the conflict with Al-Qaeda and other terrorist groups is one of armed conflict, as the US would believe, then it appears that the use of drones may be appropriate in certain circumstances. So is the US government correct in its approach to the conflict? Is this an armed conflict such that the laws of war apply, thereby allowing, provided certain other conditions are met, the use of lethal force and targeted killing? There's no easy answer to that question under principles of international law. The key questions are whether or not an armed attack has occurred, who was committed by matters, i.e. a state versus a non-state, and whether it can be attributed to any particular state, including on a theory of indirect responsibility. The key issue in the debate about the use of drones, particularly against U.S. citizens, is the clause that provides that no person shall be deprived of life, liberty, or property without due process of law. That's the Fifth Amendment. The U.S. government has taken the position, however, that in a war setting, citizenship does not make an individual immune from targeting. Various U.S. administrations have made it clear that if a U.S. citizen joins Al-Qaeda or an Al-Qaeda affiliate, that individual will be considered to be a member of the enemy and a legitimate target during combat operations. The Supreme Court has long held that U.S. citizens that join enemy forces can legitimately be classified as enemy belligerents within the meaning of the laws of war, and therefore can be appropriately targeted. But what about a citizen's due process rights, the Fifth Amendment? The U.S. government has made clear that due process rights do not require a court's opinion. The executive branch can provide due process through the various review procedures that it adopts in making its targeting decisions, at least according to former officials. Generally speaking, the Supreme Court has provided that due process requirement can be flexible, and U.S. administrations have held that the concept is not synonymous with judicial process. As a result, the current U.S. position is that if a U.S. citizen is operating as a member of a terrorist organization, that citizen can be targeted with a drone strike, even without judicial process. Well, that does it for this week's introductory podcast. Let me know if you have any questions, and I will see you next week for a new installment of 5 Key Questions.